Welcome to Ask the Attorney, brought to you by the Law Office of Chris Doscotch.
Hello and welcome. I'm Stacy Campbell. We're ready to take your calls already. The number to call, 698-3742. You can begin calling right now. Our attorney this evening is Chris Doscotch, a personal injury lawyer with a practice on North Knoxville right here in Peoria. Hello, Chris, and welcome.
Thank you. Good evening. How are you?
I'm good. It's good to see you. You're here often, a familiar face on this show. And tonight,
Yes.
We're talking about a topic that every time we talk about, the phones just light up. It's workers' compensation. Why do you think that's such a popular topic?
Well, I do injury law, personal injury, and you can have all kinds of injury cases, but the type of case that affects the most people on a global basis, number-wise, whether it's the injured person, the medical field, the employers, is workers' compensation. I mean, by far,
Right.
there's more work comp cases than auto accidents or any other type. Plus, you know, it hits home.
Yeah.
Am I getting into the doctor? Am I getting my bills paid?
Right. So workers' comp is somebody gets injured on the job and then the money that they are owed because of that. It can get really complicated. We know that. We've talked about that in
Right.
the past. So let's talk about what you have to do to prove and win these cases. Are
Okay.
they hard to prove?
They're getting harder, and I've talked about it before because of how they've changed the law since 2011. It's been politicized a little bit more, but the basic principles for proving a case have remained the same. But right now, more cases are being fought, and we're having to work a lot harder to win
Right.
them.
So I know one of the first things that you have to prove to win a case is that you had an accident, obviously, and that the accident has to be an inherent risk to your job. What does that mean?
All right, there's three types of ways you can prove accident. The main reason is inherent risk. We all lift in general life. You don't get paid for bending over, work comp, for bending over, turning, because those are ordinary activities of life. But same thing with lifting. But if your lifting is an essential part or a part of your job, I'm getting this box, I'm lifting this item, it's inherent risk of your duties requires you to do it. That's the number one way for, you know, an accident. And then there are a couple other times when things maybe it's the same risk whether you're in the general public or like going up and down stairs.
That's what I was going to say. So if you're just like walking up and down the stairs and you injure yourself, that's not necessarily a workers'
Not
comp
necessarily.
case.
It can be, and that's a frequent topic. It can be if you're doing it to a degree greater than the general public.
Okay.
Because there is increased risks of knee problems going up and down. So if you're going up and down stairs 30 times a day, or up and down a step much more than a regular person would in their average day, then it can be an
So
accident.
it would be like a repetitive injury or something, kind of like.
For an accident analysis, it would be like that, but you have to show you're doing it to a greater degree than you would be doing at home. You're exposed to that risk
Yeah.
to that greater degree.
Okay, so what if you have a condition, say you have seizures and you're on a ladder at work and you have a seizure and you fall? Is that considered a workers' comp?
That's the third type, and if you have a personal risk that causes you to get injured. So another example would be driving. If your job requires you to hit the road for work and you have a seizure, the seizure is not work-related, but you're driving the car at the time, that increases your risk of being injured because you're behind a motor vehicle. Same thing as being on a ladder. If you have a seizure and fall to the ground while you're standing on or sitting in your chair, the risk from that fall is a lot less than if you're 10 feet high. So if your job duties increase the risks to you of being injured because of this inherent condition, then it can be. So there can be exceptions to the rule, but those are the three main ways you prove an accident.
Okay, well, let's get to some questions
All right.
because we do already have some. So this question, I got hurt at work back in 2016. My boss did not fill out an accident report and sent me to the doctor. I kept working, ended up having back surgery just last month. I have an attorney and have for the past 7 months, still no work comp pay, and the surgeon says I will never be able to do my job again. Should I be getting work comp?
Well, I'm going to have to do something that you're not supposed to speculate, because
Yes.
obviously I don't have the
All
facts
of the
of the
facts,
facts
right.
of the case. I mean, the first thing that it sounds like in the question is the employer didn't fill out an accident report. That's not needed. As
Okay.
long as you report it orally or in writing within 45 days, it could be a case. But if they have a policy to fill them out and the employer's saying, well, one wasn't filled out and disputing it, that could be an area of dispute.
Okay.
The fact that the employer took the person to the doctor would seem to suggest something happened, if you can prove that. And then why the pay isn't coming, these cases are taking longer and longer because we're having to do more depositions to prove causation. Second part of work comp
Which
from accident.
we will get to that in the
Right.
next break. How long do they take from start to finish, typically?
They could go from weeks to years,
Wow.
literally. And so in that case for the 7 months, I can't speak to what their lawyer is doing or what's going on. Is there a medical dispute? Is there an accident dispute? Is there both? Is there a dispute on whether the person could be working? What you want to do is find out from your lawyer why the case is being denied, and then what steps are you trying to take to push it forward, because it is hard to get a case moving forward in work comp.
Okay, all right. Well, it's time for us to take a break already.
Okay.
But we are going to be back with more questions for Chris Doscotch about workers' compensation coming up next. Welcome back. This is Ask the Attorney. I'm Stacey Campbell. This is Chris Doscotch. He is a personal injury lawyer, been practicing law here in Peoria for 22 years, and he's here to answer your questions. So give us a call right now, 698-3742. So we've been talking about workers' compensation. It's a popular topic for sure. Now, in the last segment, we started talking about different ways that you prove these cases, what you have to do to prove the cases, and about inherent injuries to your job. So let's talk about causation. You brought that word up in the last segment. What does that mean?
Well, we were talking about what a doctor and why these cases can take so long is the topic I'm talking about today. You have to have medical testimony in most cases unless it's obviously related. So repetitive stress case, you know, if you had a pre-existing condition, you need a doctor to say that it's more likely than not that your work accident is a causative or an aggravating factor. If you don't have that testimony, you can't win. The insurance companies are hiring doctors, and many times, not all, they'll say it's not work-related. So you have to, we have the burden to prove our case and to win. So we have to go out and talk to the treating doctor or hire our own experts and take a deposition. It's costly, and you got to get on the doctor's schedule. And that's one of the big factors that really delays getting these cases going forward. But it's essential, because if you don't have a doctor opinion, you can't win.
So how does that tie into like depositions? What's a deposition? Is it doctors are giving depositions?
Yeah, they give testimony, raise their right hand, and swear under oath to tell the truth, and then the transcript's made, and then that's what the judge reads, because the doctor can't come and sit at a hearing all day to wait to come on. So it's the most efficient way to get doctor testimony. They don't testify live, and then the judge reads it at a later time. And
so then I would imagine all of that takes time, and that's part of the reason why these cases
doctors
get
booked out, and then you got to get their doctor deposition. It used to be in the olden days. Now that I'm getting older, I can say that. But it used to be we would do it on the reports, and you wouldn't do depositions. But that's not the way it is.
Are depositions done right here then, where everything happened, or do you have to travel for those?
Go to St. Louis. I was just in Indianapolis the other day, Chicago. Most of them are far away because a lot of clients, you know, don't like going. So
do you have clients then that have to travel?
No, we do that. They have to travel maybe for an exam, and then we go do the deposition. Local treating doctors we take here, but the doctors hired by work comp, usually we have to travel, and sometimes 3-4 hours.
Okay, all right. We've got some more questions coming in. This is from Donna. I walk 20 miles or more a day. If my hip goes out, would that be a work comp injury?
That'd be a lot of miles a day, so there must be like mail or water reading, or I mean doing something with...
Which, if you're a mail carrier, that would be an inherent risk, right?
Right. And walking is not, you know, I've tried those cases, and unfortunately for people that work in factory, they wear the pedometers, how many steps they're taking. It's more difficult without a specific injury, so I would say you can make the argument for a case being that. Like jumping in and out of a truck, but walking is a difficult one. It'll be denied, and it'll be up to the judge to decide.
Okay. That just, when you said it'll be denied, can you appeal these cases or no?
You can. I mean, when I say denied, I mean the insurance company denies it, then you need a lawyer to try and fight it. So the walking one would be tough. They would probably not openly accept it, and you'd have to fight. It depends on the medical testimony mainly.
Okay. This is from Dan. Had 2 rotator cuff surgeries. He thinks he will be released this week and doesn't believe he's ready to go back to work. What does he do?
Okay, if his treating doctor's releasing him, he needs to talk to his doctor and voice those concerns.
Okay.
If his doctor says, I think you're ready for it,
Uh-huh.
and doesn't put any restrictions, if you do not go back to work, you're not going to get paid workers' compensation. They only have to pay you off work pay. It's called TTD until you're at maximum medical improvement, or the employer can accommodate a restriction. So here, if there's no restrictions from a doctor and you don't go to work,
Should be able to work.
right, I mean, I don't ever want to encourage someone to injure themselves.
Yeah.
But understand, if you don't show up, you could be fired for being a no-call, no-show, and you're not going to get paid.
Yeah.
So if you could try it and see how you're doing, and then if it's a problem, then maybe call your doctor if there's any issues,
Yeah.
and then say, maybe I need a little bit more time, and give it a try.
Okay, let's talk a little bit about the benefits of a workers' comp case. So what can a judge award you? What do you stand to gain?
A judge can award access to medical care,
Okay.
prospective medical, or order the insurance company to approve treatment. They can award medical bills in the past.
Uh-huh.
They can award off work pay.
Okay. And that's just what? That's compensation you lost
Two-thirds
for
of your
being...
pay.
Okay.
And then they can award an award, or you can receive a settlement
Okay.
for any permanent disability. And there's 3 types. If you get back to your job, there's permanent partial disability. If you can't go back to your job and you lose money, you can get wage differential. And if you're unable to do any work in this market because of work restrictions, and you prove that there's no work for you, or you're medically incapable, then you can get permanent disability. And that's not granted that often.
Oh, really? Okay. Kelly has a question. If I injured myself at work and I'm cleared to go back to work and then I injure my back again, is that a new claim?
Could be. It would depend on how long you'd been back to work.
Okay.
When you got released, were
Yeah.
you symptom-free and normal
Okay.
on exam, or did you still have some problems and you were giving it an effort?
Yeah.
If it's been a long time, or you were doing really well and then you have a new incident, you're going to it's probably going to be a new case. If you're just back to work after a couple days and you exacerbate your pain, you may file another case to protect yourself, but it may still be related to the first. It may not be intervening. It still may be connected to the first accident. So it would be fact specific, but you got to watch out for that. And that really becomes an issue if someone has, like union people that work for different employers, get hurt for one, go back, get called out by another, and you're not really healed, and you have another incident,
Yeah.
and then they're pointing the finger at each other, and you're sitting there with
Yeah.
nothing coming in while they decide who's
Yeah.
responsible.
Okay. All right. Time to take another break already. We've got one more segment, though, to get you to answer these questions, and we've got a lot of questions coming in, so stick around. We'll be right back. Welcome back to Ask the Attorney. I'm Stacey Campbell here with Chris Doscotch. You handle workers' comp cases, auto accidents, wrongful death, premises liability. Tonight we're talking about workers' compensation. And you can still give us a call. We've got time to take more questions. 698-3742. We want to continue talking about workers' compensation, specifically how to determine the value of a standard case. So what are some of the things that go into determining how much a judge may award you?
So when they changed the law, they put in 5 factors. So your age, if the insurance company gets an impairment rating, your nature of your occupation, did you have any loss in earning capacity? You know, I got a no overtime restriction, or I had a job change due to a restriction, I'm making a little bit less money. How does it affect you? Does it affect you for getting better paying jobs in the market? And then they look at what problems am I having now corroborated by the records? So you can't come in and say, I've got all these problems, and the last office note says, doing great, no problems at all, and they're trying to eliminate that. So it's real important, but that part of it also is a matter of perspective when you say I'm doing great. Well, compared to how I was before,
Right.
So it's real important when you go to the doctor, especially at the last visit, that you don't want to be a complainer or nothing like that, but you want to make sure that if you are having difficulty with motion or certain activities or sleep, whatever it is, that you let the doctor know, because the judge is looking at, all right, you had a rotator cuff surgery and you still complain of some stiffness or it gets tired overhead. Well, that makes sense. But if you don't report those problems in the records and then you testify, they think, well, are you just saying it because you're at trial?
Right.
So it's real important in the last visit that you're truthful, but you also, at the same time, you make sure you explain to the doctor any residual symptoms that you have.
Okay. So I know you've mentioned this term. I don't necessarily understand it, but so I want you to explain it. What is wage differential, and how does that factor into your settlement?
Okay. So wage differential is a separate type than what I just talked about. So if you were making 14 an hour, you had an injury, and now you can't do that job, and they lower your pay to 12. Technically, you can get an award of 2/3 of the difference till you're age 67, but most people aren't going to want, you know, a check for $48 a week. So in that situation, you would just try to say, I should get a higher partial settlement because I have this lost earnings. But let's say you're making 22 an hour, and now due to your restrictions, you can only earn 10. That's a lot more substantial. You may choose to get a check. So at that's 12, that's 8. 8 times 400 is $320 a week.
You're better at math than me.
So it's 3,000 times 5. You know, then you're talking 15, 20,000 a year, and it's 10 years. You may do that rather than a settlement. So that compensates you if you have a loss, a larger loss in earning capacity.
Okay. Alan has a question. Is there a time limit related to cumulative trauma for a group of individuals that have the same injury and just realized it?
Okay, the time limit for a repetitive injury is the same as a specific injury.
Okay.
3 years from the date of accident. In a repetitive injury, date of accident is the date it manifests itself, meaning, you know, my hands are numb, I've been using air tools, and you go to a doctor and there's some type of diagnosis. Or it could be the day you report it. But the best date for repetitive trauma is that you make sure you report it within 45 days of the date a doctor diagnoses you with a repetitive trauma condition such as carpal tunnel, cubital tunnel, and then that's when the statute of limitation runs. Now, if you've been doing the job for 10 years and you've never been to the doctor and you report it now, there's no statute. But if you went to the doctor 4 years ago and have done nothing, and it's just been progressively worse, it's been more than 3 years, and you're not going to be able to bring a case.
Okay. Janice has a question. I went to IWIRC. What's that?
iWork.
iWork. Okay.
Yeah, that's a place in town that people go to, that companies send people to.
Okay. Well,
company doctor.
She went there, and they released me to work for light duty, and my doctor has me off. Do I have to listen to iWork doctor or my own doctor?
That would be a common question, and a good one. I hear that all the time. And so first, you should get a lawyer, because you're going to probably have problems.
Okay. Good
Secondly, you don't have to listen to anybody. You know, you can do what you want, but if you don't go and try working and they have a doctor, you may not get paid.
Okay.
If someone's my client in that situation, I would tell them, if you can do it, try to do the light duty, and then if you can't, then say you can't, tell your doctor that, and then we'll go to the judge, because the judge usually asks, when it's one doctor versus the other, did your client try? And if they tried it, they're almost always going to side, as long as there's reasons, with the treating doctor versus the company doctor. So it helps to try it.
Okay, okay. Here's a question from Susan. The work comp insurance will not pre-approve my MRI, and the doctor won't do it until it's approved. Is there anything I can do?
There's many things. You have your group do it. You can have your lawyer go to court and try and get them to order it, but if you want to get an MRI and you can't move your arm, you don't want to wait 1 month, 2 months. The judge, if you try the case, it could be months, but a lot of times they'll fold if you press the case for hearing. So I think you got to be aggressive to try and get them to approve it, but there's no requirement. This is a good point. People think the insurance company has to pre-approve treatment. They don't have to pre-approve anything, because they don't know what's going to be on the test.
Oh.
You have to prove that the treatment's related to your injury. So you can't force them to pre-approve something, but there's things I can do as your lawyer to try and get, especially testing, done. And if you really get stuck and you got health insurance, just get it done, because if you're going to fight, you want to know what what's wrong with you so you can get about.
And we should mention, because we haven't mentioned in this show yet, is that anybody can call you up and ask you some questions, meet with you, find out if there's a case, and there's no charge for that.
There's no consultation fee. You can email, you can call up, ask questions. Better to ask questions even if you don't want to hire a lawyer at this point, so you get the right guidance. So when you
And
do
at the
come in,
beginning of at the beginning of all of it, don't wait, until you're so far into it that maybe a lawyer can't do
and
much
that's
for you.
changed. I mean, I have a different attitude than I did 15 years ago. I'm with is litigious. And when I say litigious, I mean where everything's being fought, not the number of claims. There's less claims actually being filed, but I'm talking more cases are being fought. It's more important that you call earlier, even if you're not hiring someone. So when you come in, there's less being reactive, and we can be more proactive.
Exactly, and that's what you want. Larry has a question. I received a workers' comp award and have open medical. The insurance is refusing to pay for medication. What should I do?
Well, again, that's another one. If you have group insurance, don't suffer. Utilize it. You can pay for it and turn it in. Open medical and is something that people can either get negotiated, which is not negotiated because they want insurance wants claims closed. Some self-insureds more than others, or if your case is tried, will leave medical open.
Okay.
But people think that means you got to pay for any treatment. Not how it works. Some places are getting more aggressive in this. You have to prove every bill is related to your initial injury. So if you got a $100 prescription, how far can I go to the mat to get a $100 prescription? You can't spend more money than the medication to get it paid.
Right.
And so that becomes a practical. So one thing that person could do is maybe close out medical if possible and settle it for a lump sum of money if they have other insurance, because it's not worth the hassle. But in the end, if they won't pay for your open medical, you can go back to court and ask the judge to award it. So you have a lot of different options. That would be something they need to call. Unless it was me, then call me if I was the lawyer on it.
Yeah.
But I'm assuming not, since they're calling in. You need to call your lawyer who negotiated you open medical or you got from an award and ask them.
Okay. Here's a question from Alma. If you get hurt on the job, is work comp supposed to pay you part of your wages? If so, how long before they start paying?
Okay, so they have to pay 2/3 of your wages, subject to the minimum
Okay.
or maximum. And everything in comp is based on wages, the settlement and your off work pay. Unfortunately, whether this is fair, it's not. In a lot of cases, the less you make, the less it is. And
Yeah.
that's by law. I mean, there's some things we can't change. But you're supposed to get 2/3 of your average pay from the year before. Sometimes you can add in overtime at the straight time, it depends. And they're supposed to start paying you. You don't get paid for your first 3 days unless you're off a total of 14.
Okay.
And then they can pay you every 2 weeks. They're supposed to pay you every 2 weeks. Some places pay every week.
Okay.
But I will say, don't expect it to be regular.
Really?
Because that's one of the main, we get calls every day about
Yeah.
checks being late and
Uh-huh.
trying to stay on the insurance company to get them out on a timely
Yeah.
manner. Because your bills don't wait.
Uh-huh.
They forget about that.
Yeah. All right, we have a couple minutes, so I'm going to ask one more question. Here's a common
Okay.
question I think that you've said you've gotten before. Does the other side have the right to things I post on social media? Is it legal to tape me without permission? Can they put me under video
Right, and
surveillance?
this is one actually that I've had a lot of lately. And so they put it in here. Yes, and no. So
Okay.
no on the taping, and
Okay.
do not ever give. There's no good reason to give a tape statement.
Okay.
So if you're going to give a statement, tell them no taping. And in Illinois, they have to tell you.
Oh, okay.
On social media, make your stuff private and don't allow. And I'm not exactly sure what this means, to tag you.
Oh, yeah.
Take the tagging out.
I think most
Tagging
people
bad.
know what tagging is.
But it's bad if you
Okay.
do that. Not good if you have a case. Take that out and just stay off social media.
Okay.
You don't have to live in a cave, but
Yeah.
I mean, if it's public, they're going to get it. But also, if they request it, and like in an auto accident case, you have to provide any posting of anything relevant to your case.
Okay.
Video surveillance, even though it's better surveillance on social
Yeah.
media now, they can videotape you also,
Okay.
as long as you're in a public place and they don't come on your property. So.
Yeah. All right, well, we are just about out of time, so I want to find out how can people get a hold of you if they want to give you a call?
They can email us at chris@doscotchlaw.com, or you can call 309-681-9770.
Okay, and anything you'd like to add before we wrap it up?
No, good questions tonight.
Yeah, we did have some great questions. I don't know how you keep all that stuff in your head. It's such a complicated issue.
Well, thanks.
So,
and
Good. Thank you so much for being here and answering our questions tonight. And thank you for joining us. Have a great evening.